Hello everyone. Welcome to Manifest IAS. Hopefully you have done your exams well. Now it is time to do some sort of analysis as to what exactly the paper was about. And I am Manjunath. I'll be handling the polity questions. In total, there were 17 polity questions, and the paper was slightly a bit offbeat because some sections which were not at all emphasized on this year was like IR. Usually 5 questions were easily doable questions. That has been completely neglected. As usual, like you have an increase in the number of questions on subjects like agriculture, geography, etc. But what is very peculiar is with respect to the kind of polity questions which are being asked these days. What I can if I have to bluntly put it, like what I can very clearly see is that Lakshmikant is not so relevant even with respect to prelims these days, because the questions are purely conceptual. When I say conceptual, what does it mean? That the questions are not about the Constitution per se. They are about the interpretations related to the Constitution. That's one particular trend which I can very clearly see. So in this context, what will be helpful is your NCERTs of political theory. And someone who has a background of political science, I think the questions would be much easier to do. That's one trend which I have been seeing. Second is, questions are more about practical implementation of law, constitution, etc., rather than the theoretical aspects as well. So questions like judicial custody, police custody, etc., are about the administrative workings more than the constitutional aspects. Third is, even with the administrative questions, there have been certain in-depth questions which have been asked, so mostly closer to PubAd related optionals and all. So what we can safely say is that this should not freak you out. This should not spook you. This should be a lesson in the sense that questions are doable if you have a solid grip over what you have learned. When I say what you have learned, it could be an article in the Constitution or the Constitution itself. If you have clearly understood it, I think these questions are doable. So let us discuss questions one by one. First set of question is 1 to 4. I am referring set C. Okay. So the first question is, under the Indian Constitution, concentration of wealth violates. Now in this, we'll look at the confusions first. We'll rule out the things first. A, right to equality seems probable, but when you look at our right to equality, Article 14 to 18 never talks about any sort of concentration of wealth or wealth-related issues. It basically talks about the equality before law and untouchability, abolition of titles. It's not related to wealth. So A is ruled out. Second, is it C, the right to freedom? No, it actually promotes right to freedom, freedom to acquire wealth. Concept of welfare, yes, to a certain extent, concept of welfare, it obstructs it, but it does not violate it. What could be a better answer is, or a rather straight answer is B, DPSP, because DPSP in 39B and C has certain specific objectives set out. What does it say? There should be no concentration of wealth. There should be equitable distribution of wealth. So there is a clear-cut mention about concentration of wealth. So B is the answer. Second question, what is the position of right to property in India? Now, in this, there would be a bit of confusion with respect to right to property. Everybody knows that right to property after 44th Constitutional Amendment is no longer the fundamental right. So your option C and D, option C is ruled out. And you also know that after 44th Constitutional Amendment, it was taken to Part 12, Article 300A, it becomes a legal right. Now the question is whether this legal right is meant only for the citizens or it is meant even for the non-citizens, that is the word person. So if you look at the text, the bare text or the bare act, you can clearly see that the word no person is used, not citizen. No person can be deprived of his property except by the procedure, except by law. So it is a legal right which is available to any person, not just to citizens. So answer is B in this. Third question. What was the exact constitutional status of India on 26 January 1950? What is this date? This date is the date of enforcement of the Constitution. We adopted the Constitution on 26 January 1949. It was enforced. So enforced by that it means that Constitution got applied to India. It was put into implementation. So in that sense, when you look at what was India, if you look at the name of India, it is SSSDRI as of today. Sovereign, Socialist, Secular, Democratic Republic of India. But certain words were not originally present in the Constitution. They were added under the regime of Indira Gandhi through the 42nd Constitutional Amendment 1976. So which were the words which were added? Secular was the word which was added. Then socialist was the word which was added. So these words are, this is ruled out. This is ruled out, and this is also ruled out because India was a sovereign country, because without the word sovereign, independence does not mean anything, would not have meant anything to India in 1947. So answer is B in this. Next, fourth question. Constitutional government means. So this is a repeat question. This was there even last year as well. So first, in such type of questions, one thing you should be very clear. When I say such type of question, this is a conceptual question. So concept related question means it is not about the Constitution per se, but interpretations about the provisions in the Constitution. So we'll read in such type of questions, you should not directly go and answer them. You have to rule out every option because all options are usually closer to the answer. And it's just like your decision-making ability questions and all, where all decisions seem almost similar. So, or almost closer to the answer. A representative government of a nation with federal structure. No, this is a democratic federal government, not constitutional government. A democratic federal government may not be constitutionally ruled. A government whose head enjoys nominal powers. No, this is a republic, or this is a government like India, a government whose head enjoys real powers. No, this is also not the right answer. A government limited by the terms of the Constitution, yes. Remember, the basic function of any constitution is to limit the government, and it does it through many ways. Maybe by giving rights to the people, because giving rights will limit the government. By defining the kind of political system one would have, through this what will happen? Nobody can unilaterally change the nature of government. If it says that India will have a democratic government, nobody can tomorrow unilaterally say that India won't be a democracy. So constitutional government simply means a government which is limited by the Constitution. Limited by the Constitution means limited by the law. That is the fundamental law. A government limited by the terms of the Constitution is the right answer. So in this, the answer is D. Next set of questions, if you look in polity, that is that it starts from 12th to 20th. So let's move to 12th question. Okay, this was the question I was talking about at the outset when I began this particular discussion, where I said that some questions are purely asked to check your practical application of things. So when you study Constitution, you generally don't focus on law, but focusing on law, implementation of law is also very important. That is what it is moving towards, is what the paper shows. With reference to India, consider the following statements. Judicial custody means an accused is in the custody of the concerned magistrate, and such accused is locked up in police station, not in jail. So in this, it is asking you about two concepts. And judicial custody, like Aryan Khan is in judicial custody, etc. And also, there is a difference between judicial custody and the police custody. There are two kinds of custody. Police custody means under the custody of the police, and when the person is under the custody of the police, he will be under the control of the police. Police can investigate him, etc., and all without the permission of the court. If you say somebody is in a judicial custody, that person will not be with the police. He'll be put into jail in order to interrogate him. That there is a need for the permission of the magistrate. Now, if you look at this statement, judicial custody means an accused is in the custody of the concerned magistrate, and such accused is locked up in police station. No, not in the police station, but the person is locked in jail. So this is an incorrect statement. So the first statement is incorrect. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. This is correct. So 2 only is correct. Answer is B in this. Now, how do you prepare for all of these questions? I think you need to move beyond the basic textbooks. Most of the things have been done in our classes, like with respect to what is judicial custody, what are the rules of judicial custody, etc. and all. So there is a need to move beyond the textbook which is given, because UPSC does not prescribe you textbook. It has given you syllabus to cover. Next is 13th question. Okay, 13th question is also a practical application with reference to India. Consider the following statements. The issues related to parole, bail, etc. were in news. That is why this question has been asked. When a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. Now remember, parole, furlough, etc. are given to a person in jail. That is, he is released conditionally for his good behavior when he has shown it. But remember, usually parole or furlough, generally in any countries, it's not a standard practice to make it a matter of right. And in India, it is very clearly written as part of the law that parole or furlough is not a matter of right. Most of the times, it depends on the prison authorities who observe the behavior of the prisoner. And prison as a subject is a state subject, and it is state which has prisoners rules, etc., parole rules, etc. and all. So furlough rules. So state is the authority which determines it. So state governments have their own prisoner release on parole rules. Yes, this is correct. The first statement is not correct. Again, in this case also, B is the answer. Next is the 14th question. At the national level, which ministry is the nodal agency to ensure the effective implementation of Scheduled Tribes and Other Traditional Forest Dwellers Act? This was an act which granted rights to the granted ownership rights to the forest dwellers and also scheduled tribes in 2006 under the Manmohan Singh government. So, which is the nodal ministry under this? The nodal ministry is Ministry of Tribal Affairs, because Tribal Affairs Ministry was formed under the Vajpayee government in 1999. Naturally, it falls under it. So, answer is D in this, Ministry of Tribal Affairs. It is the nodal implementing authority for this particular act. This was a lot in news because there was a large-scale eviction of people from the forest, and Supreme Court took up this issue, and that is why this particular question has been asked. Next, 15th question. A legislation which confers 15th question, a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the Constitution of India. Now look at the articles, Article 14, Article 28, Article 32, Article 44. So what it is basically saying is, suppose the Parliament makes a law and says that henceforth executive, that is PM Council of Ministers, or the permanent executive, the police, the administrative machinery, have unregulated power. In that case, what happens? In that case, executive gets complete discretion to do whatever they want. In that case, what happens? There is no check by the law on them. As a result, what will happen? There will be a willful disregard for the law. So when I say there is a willful disregard of the law, what will happen? There won't be an equal application of law, or there won't be a right application of law. There will be a complete disregard to law, and what will happen? There will be an arbitrary application of law. So arbitrary application of law violates which one of the articles? That is equality before law, rule of law, etc., which is mentioned in Article 14. So that is why Article 14 is directly violated here. Article 28 is specifically related to religion, doesn't make any sense. Article 32 is related to enforcement of rights. That also doesn't make sense. It is just related to rights, not related to law. Article 44 is related to uniform civil code only. It is not related to criminal matters, etc. and all. So not applicable here. A complete picture is only given by Article 14. So in this case, answer is A. Next question is the 16th question. Which one of the following in polity is an essential feature that it indicates that it's federal in character? See, almost all the questions are related to concept. There's not even a single question which is straight. Again, it's asking for the concept of federalism rather than the federal provisions in the Constitution. Now, when you talk about federalism, federalism has to follow certain basic ideas if a country has to be called federal. First is there should be minimum of two governments. There should be division of powers, and the division of powers should be mentioned in the Constitution. That means that what I mean by that is state should not be at the mercy of the center. So after this division of powers should be in a written constitution so that there is lesser conflict. Now, even after this, there will be a probability of conflict. In such case, there should be an independent judiciary to resolve the disputes. India has all of this. So if you look at, first we'll rule out the options like B, the union legislature has elected representative from constituent units. It's actually violating federalism because if states do not have directly elected government, center has it, it gives an upper hand to the center. The union cabinet can have elected representatives from regional parties. This means that there is promotion of regionalism, but this is also a feature of federalism, but not essential. The fundamental rights are enforceable by the courts of law. No, this is making a constitutional government or or puts constitutionalism into practice. It is not related to federalism. So the only option which gives you which is related to federalism is the independence of judiciary is safeguarded, because an independent judiciary is necessary to resolve the disputes. For example, today judiciary has to be independent if it has to resolve the issue of agricultural laws, which has become a disputing law, or which has become a law put into dispute, which has become a law which has put center and state at loggerheads. So answer in this is A. Next, which of the following best defines the term state? Now in this case, this is slightly tricky. First you should be very clear about the definition which I gave in class. I clearly said that state is different from nation. State is a legal entity which has geography, that is territory, population, government, sovereignty, and recognition of the international recognition of other countries and all. So 5 components. Now we'll see which particular statement is closer to these 5 components. A community of persons permanently occupying a definite territory, independent of external control and possessing an organized government. See here, a community of persons, yes, there is population. Permanently occupying a definite territory, yes, there is a territory. Independent of external control, yes, there is sovereignty. And possessing an organized government, yes, there is a government also. So all 4 components are there in the first one. What is not there? International recognition, but that is not so essentially a component. So this is very close. Second, a politically organized people of a definite territory and possessing an authority to govern them, maintaining law and order, protect their natural rights, and safeguard their means of sustenance. Close, but there is no concept of sovereignty in this. There is no concept of like independent of external control and all. So this is not the close. This is not very close to what we had given the definition of state or components of state. Next, a number of persons who have been living in a definite territory for a very long time with their own culture, tradition. This is purely the definition of nation. It's not state. It's a group of people with shared history, etc. is nation, not state. State is a legal entity. It has to have legal aspects. Next, D, a society permanently living in a definite territory with a central authority, an executive responsible to the central authority, and an independent judiciary. No, this is again talking about government and its people. It's not talking about external factors like sovereignty, etc. and all, free from any sort of external control. And so the closest answer or the best answer among this is A. So A should be the answer. Next. So this is 18th question, 17th question. Next is the 18th question. 18th question is also slightly tricky if you have not read Supreme Court properly. So we have generally read about High Court judges being appointed as acting and additional judges under 224, 224A. This is slightly different. This particular question is asking about Supreme Court retired judges being appointed back. So that usually happens. This is given under Article 128. This was there in use till 1975. After 1975, it has been put into disuse. So any retired judge of the Supreme Court of India can be called back to sit and act as Supreme Court judge by the Chief Justice of India with the prior permission of President of India. Yes, Article 128 clearly says that. A High Court in India has the power to review its own judgment as the Supreme Court does. Yes. Review judgment or review petition is given under Article 137 for Supreme Court. It's also there for High Court, also constitutionally mentioned. The High Court also can review its own judgment. Then only you can go and challenge it even the Supreme Court also. So this is also correct, and one is also correct. So the answer in this is C. Next is 19th question. Which of the, with reference to India, consider the following statements. I had told in class that this year there will be a question on citizenship because it's a very, it was a hot topic due to Citizenship Amendment Act, etc. and all. So there has been one question. There is only one citizenship and one domicile. Yes, India has single citizenship concept and one domicile, very clearly written. Second is a citizenship by birth can only become the head of state. I discussed this in US president, etc. and all. It's only in US that a person by birth only can become the head of the state. In India, this is not the case. A citizenship by birth or by citizenship by any other means can become the head of the state. So first is correct, second is incorrect. A foreigner once granted the citizenship cannot be deprived of it under any circumstances. No, because in India, termination, etc. is a process. It's not only for foreigners, it can be even done for citizenship in India by birth as well. You can take it away under certain circumstances. So this is a far-fetched statement. You can easily guess that it can be easily taken away as well. So second is incorrect. Third is also incorrect. The first statement is correct. So in this, the answer is A. Next, which of the following, that is 20th question, which of the following factors constitutes the best safeguard of liberty in a liberal democracy? This is a very, very tricky question. Seems very simple at the face, but it has certain inner dynamics. I feel if you don't know liberal democracy, then it is very difficult to answer this question. This is a purely political science question. In our classes in political science optional, we did discuss what is liberal democracy and contradictions within liberal democracy. Remember JS Mill, you'll get the answer. So what is the problem of which of the factors constitute the best safeguard? What is the problem in a liberal democracy? A liberal democracy is a mix of two things. It is liberal It is democracy. Liberalism means one which supports the idea of liberty. Democracy means rule by the people. So democracy is a kind of political system, liberalism is a kind of ideology. These two come together. Is India a liberal democracy? Yes. India has democracy, vibrant one. Does India respect liberty? Yes. And under Article 1922, liberty is deeply entrenched as part of the political system and also the constitutional values. So, what is the danger India faces or any liberal democracy faces? The danger which a liberal democracy faces is the challenge to liberty. How is it? The biggest challenge to liberty in a liberal democracy is majoritarianism. What happens in a democracy? In a democracy, there is always a possibility of majority community electing their own government, because democracy is all about numbers. So when such a kind of government is elected, that government will naturally work for the majority only, and the minority will be not protected. Their liberty is in danger. So how do you protect? This question is exactly asking, how do you safeguard liberty in that case? How do you protect liberal democracy from majoritarianism, which is the classical problem which G.S. Mill talks about. So a committed judiciary, no, this is actually wrong. This should be reverse. It should be independent judiciary. If there is an independent judiciary and executive which is directly elected by the people, and which could be a majoritarian government, can only be checked by an independent judiciary, that is incorrect. Centralization of powers, this is also incorrect, because excessive centralization of powers will further strengthen the executive, which is already majoritarian, so that is also incorrect. The problem emerges in C and D. Many could think an elected government could actually tone down the authoritarianism, but it is incorrect, because liberal democracy already has democracy in it. There is an elected government, but that elected government in itself could become a danger, because through an elected government only a majoritarian government can be elected in a liberal democracy. So C won't be the answer. So what could be the answer? Now imagine a situation where there is a majoritarian government elected. Take the example of India itself. Today there is a majoritarian government with a majoritarian leaning itself. In this case, how do you moderate, how do you control or regulate the executive, that is the PM and the Council of Ministers? By strengthening two other bodies, that is judiciary, and the second one is the parliament. That is why this government is against the parliament. This government is trying to manage judiciary. So the best way would be what? Have a strict separation of powers, meaning that is executive performs executive functions, judiciary performs judiciary functions, and parliament performs parliamentary legal functions, law functions, etc. So when there is this clear-cut separation of powers, executive, which is majoritarian, won't get the authority to regulate the other two organs. The other two organs will check them. So separation of powers is the best method to check a majoritarian government, which could be a threat to liberty under liberal democracy. So answer is D. Next. So we have finished next set of questions. There are 4 questions left from 27 to 30. So th question, again a conceptual question comparing the parliamentary system of British and the parliamentary system of India. We adopted parliamentary democracy based on British model, but how does our model differ from that? First statement, as regards legislation, the British parliament is supreme or sovereign, but in India the power of parliament to legislate is limited. Yes, this is a correct statement, because parliamentary laws are not universally applicable to India or entire India. There are certain areas where it is not applicable. Parliamentary laws are also brought under judicial review, they can be struck down, etc. But there is no such system in UK. UK Parliament is the sovereign. That's why David Dicey says UK Parliament can do anything except changing sex of a person. So there is no concept of judicial review in UK, etc. So UK Parliament is sovereign. So first statement is that it is correct. Second statement, in India, matters related to, read this statement very carefully, because this might have confused most students. In India, matters related to the constitutionality of the amendment of an act of the parliament are referred to the constitution bench by the Supreme Court. Look at the term here. In India, matters related to constitutionality of the amendment of an act of the parliament. What it is basically saying, suppose there is an act of parliament or there is a parliamentary act passed by the parliament. Now the parliament wants to amend it, so it is amended. So imagine anything like, so suppose there is suppose there is Citizenship Amendment Act, right? Originally there was a Citizenship Amendment Act 1955. Now it is being amended through Citizenship Amendment Act 2019. So when this particular law is under scan or under question, it will be taken to the court. So if it is taken to the court, is it mandatory in the court to examine it by a constitutional bench? No, this is incorrect. You will get confused by the word constitutionality of the amendment of the act. It is checking the constitutionality of the act, the amendment act, not constitution per se. So if it had been constitution or checking or inquiring into matters related to constitution, this might have been correct. But it is saying that an act of parliament or an amendment act is referred to the constitution bench, not necessarily. A constitution bench is formed usually in very limited cases like presidential, vice presidential elections. So this is an incorrect statement, though it seems superficially, if you look at it, seems correct. This statement is correct. So answer in this is A is the answer. A1 only is the answer. Next. '28th question. This is a question which is from the administration part, and I have told it, I mean, in my last year analysis and the previous year analysis in class, multiple number of times I have told, administration questions are also to be focused on. So we did governance. I did not really touch upon this, but yes, I mean, this is something very remote question which has been asked. So very detailed, minute question has been asked, looking at the history of administrative reforms. Now, the first statement says what N. Gopalswamy Iyengar committee suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reform and promoting it. So basically it is saying that N. Gopalswamy Iyengar committee, which was formed in 1950, recommended that there should be a separate ministry for administrative reforms. If you look at the report per se, the PDF which I saw, it doesn't clearly mention anywhere about formation of a ministry. So it talks about ministry reorganization, various ministry changes, etc. and all. It doesn't talk about a formation of any new ministry. There is no evidence of it. As of now, I take this answer, I take this statement to be wrong. I did not find any supporting evidence to prove this statement. Second statement, there is a supporting evidence I've directly got that Department of Personnel, which was formed, it was formed in 1970. It was formed on the recommendation of the first ARC report, ARC commission, which was formed in 1966. And it recommended that it should be put directly under the in charge of the Prime Minister. Later on, it was transferred to Home Affairs, and later on the name was changed and made into a ministry after a few years. It is a dedicated ministry, Ministry of P, which you have today. So second statement is correct. First statement is incorrect. So answer in this is B2 only. Next is the 30th question. Again, questions more related to politics, practical implementation related to politics. In this also, you could use your generic knowledge, and also in terms of how you have studied. If you have generally known certain things, you'll get to know. You can answer this. The first question, in India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. No. Today you have a limit that you can only contest from not more than 2 constituencies. Earlier, there was no limit at all. There have been cases where people have contested even from 43 seats and all. So first statement is incorrect. Second statement, in 1991 Lok Sabha election, Sri Devilal contested from 3 Lok Sabha constituencies. Yes, he was the Prime Minister, Deputy Prime Minister under VP Singh government, Chandrasekhar government, 1989 elections and all. After that, he contested from 3 seats. Vajpayee also contested once from 3 different seats. Now, as per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-elections to the constituencies vacated by him. You know that there are, if a candidate is contesting from 2 seats and he wins in both, he has to vacate 1 seat. Now there will be by-elections. Who will fund that? No, it is not funded by the party and all, because if it was funded by the party, Election Commission of India would never have proposed or would never have cribbed about the wastage of money, national resource, etc. and all, money, time, etc. and all. So this is incorrect. 2 is correct, 1 is incorrect. So answer in this is 2 only. B is the answer. Next, the last question of polity section is, oh, I think this ends. So in total, 70 questions. Hopefully you have done well. Even if you have not done well, that is perfectly okay. Because these are learning lessons for everybody. Someone who has done well, I think, based on the cutoff, etc., you should immediately jump to mains preparation. Someone who is on the border still should go for preparation. Someone who is very clear that he or she is not going to clear the exam, don't get disheartened. You can really do and clear this exam. It just needs some sort of smart work. And this paper clearly proves that it's not purely hard work. Smart work is what is needed. Thank you. Have a great day.